Hello everyone, this is Shiv, a legal intern at LEXIS and Company and currently pursuing BLLB honors from Central University of South Bihar. In today's second session, I am going to deal with some points like when court can alter or amend a charge, what are the basic rules as to charge and the trial of charge. Further then, I will go through some exceptions to the basic rule of trial of three offences of the same kind within a year. In the previous video, I had gone through the introduction part. Further, I had gone through the purpose of charge, types of charges, types of cases where charges are framed. Then I had gone through the contents of charge. Then at last I had gone through the particulars as to time, place and person. So let us start this video from when court can alter or amend a charge. Section 216 states the conditions under which the court can alter or amend or add to any charge. Before the judgment is pronounced, the court can alter or amend any charge. Such alteration or addition has to be read and explained to the accused. If in the opinion of the court, the addition or alteration to the charge does not prejudice the accused in his defense or the prosecutor in the conduct of his case, then the court may alter or amend the charge and proceed with the trial according to its discretion. But if the court is of the opinion that the alteration or addition to the charge is likely to prejudice the accused or the prosecutor as aforesaid, then the following the alteration or amendment, the court may at its discretion either direct trial or adjourn the trial for such period as it may consider necessary. If the previous sanction is necessary to be obtained for the prosecution of the offence stated in the alteration or added charge, then the court shall not proceed with the case until such sanction is obtained. Let us see the basic rule as to charge and the trial of charge. Section 218 to section 224 of the code deal with the joinder of charges, which means that in certain cases more than one accused may be tried for the charge of the same offence. Section 218 of the code deals with the basic rule as to the trial of the accused. Section 219, 220, 221 and 223 of the code deals with the exceptions to the basic rule. Section 222 provides for the circumstances under which the accused can be convicted of an offence he was not charged with at the beginning of the trial. Section 224 deals with the withdrawal of the remaining charges when one of the several charges has received a conviction. Section 218 of the code states that for every offence that person is accused of, there shall be a separate charge and each of those charges will be tried by the magistrate separately. However, if the accused person desires the request the magistrate in writing and the magistrate is of the opinion that such a person would not be prejudiced in the case, the magistrate may try together all the charges or any number of charges as he may deem fit. Now let us see exceptions to the basic rule of trial of three offences of the same kind within a year. Section 219 of the code states that when a person has committed more than one offence of the same kind within a span of 12 months from the first to the last offence, whether in respect of the same person or not, he may be charged with or tried at one trial for any number of the offences which shall not exceed 3. Trial for more than one offence contains, according to section 220 of the code, when the series of the acts are such that they are so connected that they form part of the offense, part of the same transactions, and more than one offence is committed by such series of acts, then the accused may be charged with and tried for every such offence in one trial. In case the person is charged with one or more offences of criminal breach of trust or dishonest misappropriation of property as provided in subsection 2 of the section 212 or in subsection 1 of the section 219 of the code, and when the person is accused of committing one or more offences of falsification of accounts for the purpose of facilitating or concealing the commissions of that offence, then he may be charged with every such offence and may be tried for all such charges at one trial. If the acts mentioned above constitute an offence falling within two or more separate definitions of any law for the time being in force, that then the accused person may be charged with such offences and tried for them at one trial. In case of several acts, when either one act by itself or more than of those acts by themselves constituting an offence combined together to constitute a separate offence, then the person accused of them may be charged with the offence constituted by such acts combined or for any offence constituted by one of those acts or more than one of those acts. That's all for now. Let us meet in the next session dealing with some other new topic. So please do like and subscribe the channel. Thank you.